Good morning, everybody, and welcome to Family Law Assistance. I can't believe it's Friday already. I seriously don't know where the week has gone. So, if you're joining me this morning, this Family Law Friday is going to be dedicated to allegations of abuse. Now, whether you're the person that's alleging abuse or whether you're the person that has been accused of allegations of abuse, we are going to talk about it today. In the over 14 years that I've been doing this, I have had, oh, that's right, no case that have gone through family law child contact proceedings without allegations of abuse. You heard me right. Every single case that goes through and that we've dealt with, and certainly the courts will have dealt with, will usually have allegations of abuse. And often they are a bar for contact with the non-resident parent progressing. If you're watching this and you're kind of nodding thinking, yep, that's me, then this is the video for you. Now, I've been doing this for a long time, like long time. And way back when, I would always usually be the first person to get the courts, or certainly encourage the courts to investigate these allegations of abuse. Because here's why. Often when there were allegations of abuse, it would stop the contact with the children progressing. And way back when court proceedings used to last a heck of a lot longer than they do today, they would be constantly raised as a bar for preventing contact. Whether true, false, indifferent, it doesn't matter. Court hearings and applications used to go on, honestly, for years. And that used to be quite a frustrating process for everybody really involved. For the non-resident parent, the fact that contact couldn't progress because of allegations of abuse was frustrating. And similarly, for the person that was alleging the allegation, there just never seemed to be any kind of resolution. And of course, ultimately, the children were the ones that ultimately were failed, because it's not good for children to be stuck in court proceedings. So way back when, I would always be the first one to advocate something called a finding of fact hearing. Now, some time ago, there's a bit of legislation that the courts beefed up, for want of a better term, and that was, write it down now, Practice Direction 12J. And essentially, Practice Direction 12J pretty much beefed up what was already there. So Practice Direction 12J essentially said that all allegations of abuse needs to be investigated. And the way that the courts would do that in family law would be through a finding of fact. If you know, you know. But the problem was that when you've got a scenario where every single case that comes through and walks through family law doors had allegations of abuse, listen, that's a lot of admin and that's a lot of court time. So what courts do is that they interpret Practice Direction 12J. They'll look at the allegations, and trust me, I've seen allegations from, well, they looked at me a bit funny as an allegation, all the way through to something very sinister, macabre. I had one person that I was assisting who had, I think he'd done time. It was a long time ago. So the broad spectrum of what constitutes abuse is huge, and especially nowadays when there's new laws and legislation brought in, such as coercive control, it's something that the courts really have, to be fair to them, taken seriously. Now, of course, the courts don't know you from Adam, so of course they're going to err on the side of caution. They're not there to say, I believe so-and-so or against so-and-so. If you're dealing with a child contact matter, the court has to have primary concern for the child. Now, like I said, way back when, I was an advocate of just investigating those allegations. For good, bad or indifferent, something I noticed was very clear. And that was at the end of investigating those allegations, whatever happened, whether the court found in favour of one party or another, one thing was clear. And that was that it drew a line under the allegations. It meant that if it found against, there were suggestions on how to move things forward. If it found against the other party, well, then they'd have to put up and shut up. So Practice Direction 12J kind of beefed that legislation up and sort of insisted that the allegations of abuse needed to be dealt with from the get-go or as early as possible. Now, in all reality, that means you're going to have to investigate them from the get-go. So what's the process in that? How does that even work? Well, I won't lie to you. Of course, that dealing with allegations of abuse does create a delay in child contact proceedings. Of course it does. But they are dealt with. And like I said earlier, there is a line that's drawn underneath it, whichever way the cards fall. I also want to point out, actually, that it's human instinct to want to defend against the allegations. And often when one parent is making allegations of abuse against the other, it's human instinct to kind of go, yeah, but, what about, yeah, but. It's only if the court think that those allegations are worth commenting on that you should comment upon them. And the reason I say that is because actually you'll end up getting distracted from why you're there in the beginning. I've mentioned this in a bajillion lives before, that if words were like currency, you don't want to waste them in the limited time you have in court. Now, it has been a tactic that one party who is alleging domestic abuse or alleging allegations for the whole court hearing to be taken up with you defending the allegations. So to be clear, it's only if the court suggests that you have to answer those allegations. Now, the court will do that, as per Practice Direction 12J, the court will do that in what's called a finding of fact hearing. And there's a whole procedure dedicated to just how the courts will look at and deal with a finding of fact hearing. For a start, the court will ask the person who is alleging abuse to make a table of allegations. And the table is called a SCOT Schedule. And the table consists of 3 columns. So in column 1, the person that's making the allegations will list out individually their allegations. And it's usually supported with a statement. Now, the boxes, I might add, are really small. So very often there's only a few words per box that can go in the allegations, a summary, if you will. And it's normally supported with a statement. Column 2, well, that's where your chance to respond to those allegations are. Again, the boxes are small, so they should be supported with a statement. Column 3 is for the judge's comments. Now, of course, the court can deal with a heck of a lot of allegations. I mean, I remember one SCOT schedule, it had something like 50 allegations. Well, listen, if the court is going to call a trial to deal with 50 allegations, trust me, there is no court time that is going to be prepared to deal with 50 individual allegations. So if there are a lot of allegations, the court will call something called a filter hearing to, you got it, to filter the allegations to exactly what are we dealing with. Sometimes historic allegations have just will probably been thrown out. I mean, is it really relevant that something that happened 12 years ago, is that going to impact on something that happens today? After the filter hearing, the court will literally filter down the hearings from the bajillion of allegations to ones that the court are actually going to look at. And it is in that moment when the court have pulled down the allegations that you have an opportunity, I would say, to give in your evidence, statement and evidence. Because up until that point, your position may simply be, well, that didn't happen, or I refute the allegation. There isn't enough paperwork to perhaps send in all the evidence for the potentially 50 allegations. The court may want disclosure. Court may want disclosure, maybe like GP records or police records or anything that it might feel relevant to those applications. The court may also want to have witnesses. In fact, the person that's making the allegations may want to call witnesses to the court. I would stress, however, that witnesses, often friends and family, because listen, we're in a family court here. I'll always be very, very careful about witnesses that you bring to court. Because look, let's be real with each other. If you're just bringing your mate, they're hardly likely to say that you're a horrible person, right? Character references are usually a no-no. I also have to put that in the same vein as photographs of children. I mean, when have you ever seen a picture submitted to court of a miserable child? So if you are going to call witnesses, make sure that they are relevant to the specific allegation that the court are dealing with. The court will then call a contested hearing. And it's at this point where bundles are involved, the court will hear evidence, and you have an opportunity to question, challenge, cross-examine the other party and or the witnesses. Now, I would point out something that's really important and often gets lost, actually. This contested hearing does not carry the same burden of proof that you would find in a criminal court. In a criminal court, one has to prove something beyond a reasonable doubt. Hence, you get the terms guilty or not guilty. Now, the term beyond a reasonable doubt, let's be real, means that the burden of proof, it's set pretty high. The court has to be bloody sure that you did it before they pass down a guilty verdict. But family court is civil proceedings. And yeah, it's not quite the same. So the burden of proof is based on a balance of probability, which is the court saying it's not quite so eye-catching or sexy, I grant you. It is more likely than not that this happened based on a balance of probabilities. So when you have that, it's not a case of guilty versus not guilty. It's a case of it's more likely than not that this happened. Now, at the end of that, like I said, the court draws a line under it. So if the perpetrator or the alleged perpetrator of abuse has been found against them, then they will have probably a list of suggestions to overcome that. Courts, generally speaking, don't actually care what you've done. What they care more about is what you're doing about it. I've seen so many cases where there's been a lack of insight and a lack of personal responsibility. But I mean, hey, that's in life, right? I've also seen the reverse is true. And I've been in many finding of fact hearings and trials where the person that's alleging the abuse has been found to be, bluntly, just a liar. So it's not black and white. I wish it was, because honestly, it probably would make all of our lives a lot easier. However, there is a process involved. So if this is you and you're kind of watching this and going, it's totally relatable, drop some comments. How have you found the process? Have you gone through a finding of fact? Are you facing allegations of abuse? And of course, it goes without saying that if you need any further help, holler at us, because we're always here to help. Guys, have an amazing rest of your day. Over and out.